to get in and get out. And there's a videotape of my brother, of course, who is now deceased, trying to, with the newspaper there, showing how he would have to drive through the front yard, wiggle between the trees in the yard, get to the back of the house, and then come out into the main road to get off the property. And with that, blocking the mail, they came in and took the mailbox up from the front of the house and put it in our backyard. So right now we get our mail in the backyard. They sent, the city of Satsuma on their letterhead, sent a letter stating that the back of the house now is where will be our legal address, essentially, 409 Powers Road, something. So the mail truck now has to come off the road, down the little trail, into our backyard to bring the mail, which is totally illegal, according to the statutes for the United States Postal System. It says it has to be on the road and the truck has to be able to access the mailbox, but I don't know of any other persons who get their mail actually in their backyard. All of our services, regardless of whatever it is, it comes to the back of the house. With the fence that was built across our street, where Hilda Drive, to block us from the front, we attempted to take it down or tore most of it down. We were arrested and charged with a criminal misdemeanor based on our lawyer's advice. And just as an aside, we've had 4 attorneys, one from the NAACP Redress Committee, and one from Texas, 2 from Alabama, one from Montgomery, and one from Mobile. The one from Mobile, in my opinion, I think that he didn't know real estate law, that he was intimidated by the court, and the one from Montgomery collected his money, he left, and we never did hear from him again. The one from Texas definitely threw us under the bus. While we were in court, he was buddy-buddy with the lawyers, didn't talk to us much, and at one point gave me a blank sheet of paper and asked me to sign my interest over to the people who are trying to get us off of the property altogether. And he left. We didn't get a referral to another attorney. He collected his money, and he was done. But we've been told by numerous attorneys that a lot of attorneys are afraid to go into the Southern District of Alabama. So then after they closed the road, some years passed, and they started to develop the property that the court had awarded them, our family's property that the court had awarded to these land developers who had never been on the property. So the court was wrong because the law clearly states that you cannot claim title to property, acquire a title to property that you have never been in possession of. And they had never been in possession of the property. It's only the heirs of John Hilliard. And there's nothing in the records that transfers land from our great-grandfather's deed to these people. There's a series of deeds that they filed and corrected and did a number of things to, but nothing that transfers it from our great-grandfather's deed to any of them. The last deed that they filed was actually written in Gilbert, West Virginia, and the company out of Gilbert, West Virginia is called Industrial Industries. Industrial Industries owns Gilbert Leasing, and Gilbert Leasing is a company that sued my mother. But ironically, when Gilbert Leasing sued our mother, it was technically out of business. It had been dissolved. And I don't know if your listeners are familiar with Industrial Industries, but it was owned by James Buck Harless, and he's a millionaire coal miner. He's now deceased. But the person we're dealing with now, who is trying to claim title through all these fraudulent documents and doing all of these things, is the grandson of James Buck Harless. So it would stand to reason that this Industrial Industries out of Gilbert, West Virginia has to bear some responsibility because the company that supposedly sued our mother was under that broad umbrella. So we've been in court for a number of years, back and forth, off from work, paying the attorneys, making sacrifices, doing all that we can on principle. Because in this day and age, no one would believe what we are actually going through. When both of my siblings passed, the funeral car had to drive up into the backyard to pick us up to take us over to the church for the funerals. Anyone who comes has to drive up to the back of the house. If you want to get into the front, you would have to walk around the house to come to the front door. It's humiliating, to say the least. And then to make things worse, now when we're home, the city of Satsuma is allowing, whether we've met with the city of Satsuma, we're trying to reason with them, are allowing houses to be built where their backyards back up to our front yard. And Mr. Kingya, I sent you some pictures of that. And it's like, how can somebody in any kind of God consciousness treat another person like this? And I don't think that the actual people in the houses are aware, or they could be, that their backyard, the fence that separates their backyard is between their backyard and our front yard. And it's like we're in a little capsule where this privacy fence runs and encapsulizes us into this 5-acre tract, because they want us to believe that we only own the 5 acres, and it was originally 52 acres. And it does not appear that we are going to get any kind of fairness or equity with the courts in Alabama. We've been in court for 13 years. All of the documents, including the 1935 case, 1DIV 987, all of those things have been before the court. There was also a motion for them to open the road back up. I mean, the least they could have done, one would think, is to give us access to the front of our house. In fact, the deed that this MKH Harless, which is actually the same people as the Gilbert Leasing Company, they're all the same people, his deed states and is recorded in the public record that Hilliard Drive is to be open for our access. When the court granted them that part of the property, it says that that roadway to the front of our house was to be open for our access. So when we informed the court and the local police and local authorities, well, the deed says it is to be left, the court refused to grant us access. That violates state's law, because the law says that if an easement or roadway, whatever you're going to call it, has been there for the statutory period of time, no one can change the character of that roadway or easement or way in and way out. Every curb, every crook, every bump has to stay the same. But it's not the same for us. It's as if the law, as it is written, does not apply to us. It applies to everyone else, but not to us. Before my sister passed and they blocked the road off, they said that it was to be closed temporarily. But this is not temporary. Temporary will be something like a few days, maybe a month or two, but certainly not years. So at any rate, this is where we are. And now we are blocked in, can only access the property from the back. The court denied whatever is put in for us. The court denies it. And I was reading where, and then for a fraud upon the court, because these people know they went in there with fraudulent documents, nothing that transfers anything from our heirs to these people who are claiming title to it. Excuse me.
We've got the phones going off in the background. If we can put them on vibrate or something, that'd be great. And how is my audio coming in? Because I got knocked off just a little while ago, so apparently we were having some technical issues, so I'm actually on. How is the audio coming in? Are you guys able to hear me okay? Am I coming in clear?
You're coming in clear for me.
Sure.
I don't know about it.
Okay, good. Perfect. Okay, good. That's what I would need to make sure. Okay, go right ahead. Continue, Shirley. Let me brief them. So those that are just calling in, because we got the lines are blowing up, and we appreciate our callers. Thank you for your patience. We appreciate that. We're going to go to the phone lines in just a few moments. So for those that are just now tuning into the show, you're listening to our honored guest, Ms. Shirley Johnson, whose family owned property in Satsuma, Alabama. And the Johnson family has been going through some atrocities and living in a Petite APARTHEID state. They have property, and the state has allowed industrial industries to come in and basically put a privacy fence in the front of their property, the front door of their house, essentially, and told them that you can only use the back of your house now. You can no longer use the front door. Everybody has to use the back door as an entry and exit, period. And they tried to remove some of these items that was these barricades that was placed in front of their property that they own. This is private property. And they ended up, some of their family members were charged with a criminal misdemeanor, a crime for removing items and things and barricades off of their property. So that's what we're dealing with right now. She's going to tell you a little bit more about that in just a few moments. How you doing, Shirley? I know that this is a lot. I know it's a lot.
Yeah, it's a lot, and and it's very stressful. And the other thing that happened, the last time we were in court, in federal court, we thought that we have a better chance if we filed it in federal court, which is a constitutional issue. It is a violation of our constitutional rights to be set aside and treated differently because of our ethnicity. You can't do that. That's it's just it's a constitutional violation. And it was a pretrial conference. And at that time, we had an attorney from the Alabama NAACP Redress Committee that we were referred to contact them. And the magistrate judge said to us, when we explained to him that the entry to the house is blocked. We can only access the house and the property from the back. And actually there are 4 structures on that part of the property. And you can only get to it from the back. He looked at us and he said, you may not like this, but you just have to get used to it. And I said, but sir, you don't understand. We cannot get to the front of our house. That we can't get to it. You have to drive up to the back, get out of your vehicle. If you walk up, you have to walk around the house, all the way around the house to come to the front door, which logically doesn't make any kind of sense when everyone else drives up to the front or the side of their house and access the front. Everyone else gets their mail at the front of their homes in their mailbox, not in their backyard. And it's not, when I say in the backyard, it's not like 2 or 3 steps from the road or the street. The vehicle has to drive up and come into the yard to deliver the mail. But there are people, I don't know about other people, but for us to be treated this way because of the color of our skin is illegal, to say the least. And we've contacted a number of sources. I was referred by Leslie Prawl. Leslie Prawl, I think, used to be with she used to be with NAACP. Leslie Prawl referred me to the Fair Housing Committee with the Mobile County. So I contacted the Fair Housing with the head of that organization in Mobile County is a lady named Teresa Bettis. So she and 3 of her colleagues came onto the property, and they were just aghast. They were saying, how could this be happening? This is just discrimination. This is horrible. It's horrible, and we've got to get to the bottom of this. And we talked back and forth. I filled out the form, signed the documents, sent them the information, and nothing happened. We had a meeting this past fall, 19, in October, I believe it was, of this past year, with the city of Satsuma to try and reason with them to get them to understand that what you are allowing to happen is a constitutional violation of our rights to be treated like everyone else. And the law says it's a violation of your rights to be singled out and treated differently because of your ethnicity, your race, your religion, the color of your skin. It just so happens that we're the only African Americans in that particular area where our property is located.